Hi, I'm Misha Allen. I'm Senior Lecturer in Law, specialising in criminal law. I teach on the undergraduate programmes and also on the graduate conversion course. And I also research. I'm researching currently into mercy, pardons and forgiveness in criminal law. Criminal law is one of those subjects that is everywhere, on TV, on the media. You have your programmes like CSI, you see it in the newspapers, it's all around us. So when you're thinking about studying it, you may even have that glamorous image of criminal law. On the other hand, I suppose you may have an image of lawyers poring over these dusty old tomes in a library. The truth, I guess, is somewhere in between. What I'd like to show you is that law is steeped in history, but what we need to do as lawyers, whether we're academic or practical lawyers, is to extrapolate those areas of history and see how they can be applied today. One of those cases is a case involving 4 shipwrecked sailors. The case is called Dudley Stephens, probably one of the most famous cases in English criminal law. In 1884, a group of sailors became shipwrecked and managed to escape from the boat that they were on in the South Atlantic, which had got into trouble in high seas. The 4 sailors managed to find a smaller boat on which to take refuge. After 7 days without food and 5 days without water, they realised that they were all close to death. Dudley, one of the sailors, proposed to the others that they ought to draw lots in order to decide which of them should be the one to die and feed the others. One of the sailors decided not to take part, the other was far too weak to make a decision either way. Dudley drew the lot and decided that the cabin boy, who was the weakest member of the crew, Richard Parker, would be the one to die. They decided to cut his throat and eat his flesh and drink his blood, and they survived for another 4 days, at which point they were rescued. On being rescued, they were quite open about what had happened, and they were convicted in a criminal court for murder. They pleaded the common law defence of necessity. The court, perhaps unsurprisingly, rejected that plea and found them guilty. From that moment, it became apparent that there was no possibility of a defence of necessity on a charge of murder. So would you have convicted the sailors? What do you think? Should they have been guilty or not guilty? It might be difficult to put yourself in those circumstances and know exactly how you would act. On the other hand, you may feel that there is never any excuse for murder, however dire the circumstances. The courts have had to deal with similar dilemmas and work out how to apply the law of Dudley and Stephens in a similar way. For example, let's imagine that a doctor wants to perform an operation without the consent of the parents on unborn conjoined twins. One of them is taking the life of the other. He wants to end the life of one in order to save the other twin. Is he convicted of murder, or does he have a common law defence of necessity? In the same way, what about a head of state who wants to shoot down a hijacked passenger plane which is heading for a skyscraper? Should the head of state also be guilty of murder, or is there a defence of necessity available to him? How can we extrapolate the rules in Dudley and Stephens and apply them to very real situations that may come before a criminal court today? You'll approach these and other moral dilemmas during your criminal law course here. What we will teach you is how to extrapolate those legal issues and turn you into a critical thinker. Critical thinking comes about through exposure to academic legal journals, through reading cases, through analysing legislation, and learning to build arguments and present them in court. You might even put those skills to good use by preparing and presenting a case in our mock courtroom.